Hello everybody, nice to see you. It's a beautiful day today here in Great Neck. I wanted to share some great information with you. Today's topic is, when you bring a medical malpractice lawsuit, why do you actually have to share copies of your medical records with the doctor and his attorney during the course of your lawsuit? Why do you have to do that? You want to know the answer? Come join me in this walk around the neighborhood on a gorgeous day today after it snowed. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, it snowed last night and now it's melting. It's just a great day to walk around. I want to share this terrific information with you. So let's talk about today's topic, which is, when you bring a lawsuit against your doctor, you obviously believe that he was careless and that his carelessness caused you significant harm and injury. And now we have a medical expert who has confirmed that you have a valid basis for a case. Shortly after starting your lawsuit, we are actually required to give copies of your medical records to the defense. And you might be saying, wait a second, why do we have to do that? I'll tell you why we have to do that. It's because you are claiming that since the doctor was careless and caused you harm and injury, you suffered significant physical harm and injury. And now the attorney who represents the doctor says, how do we know that for sure? Okay, you're telling us that, but how do we really know? And the way that they really know is by giving them copies of the medical records that we have already obtained to evaluate your case. And you might be saying, okay, that's fine. But is there more? Actually, there is more. Why is that? All right, so here's the scenario. Now you've started your lawsuit. The doctor and his attorney have answered the allegations. They have said, listen, we did nothing wrong. And if we did something wrong, so did you, Mr. Patient. Hey, nice to see you, Trey. So did you, Mr. Patient. And then they say, you know what? If we did something wrong, and so did you, Mr. Patient, guess what? Your injuries really are not as bad as you claim them to be. Not as bad? Are you kidding me? Well, how do they really know? They don't know, and they won't know until we give them copies of the medical records that we actually obtained to review your case. And then they say, well, that's very nice. We're going to read those records. But how do we really know that those records are really the patient's records? So they do one of these trust but verify things. Now, what does that mean? It means they will go ahead and read through the records that we copy and give to them, that we obtained on your behalf. But then they say, you know what? We want to get copies of the patient's records directly from the patient's treating doctors. And we say, go ahead. Well, you might be thinking, okay, they can knock on the doctor's door and say, hey, listen, we represent the doctor who's being sued in this lawsuit by this patient. Would you please just turn over those records? They'll say, no, can't do that. We are required to get a permission slip from the patient that authorizes anybody else to get copies of their records. So we call those permission slips authorizations. And they have an acronym for it. It's called a HIPAA authorization. And that will allow that will allow the patient's treating doctors to give copies of your medical records to the attorney who represents the doctor whom you have sued in this case. Once the doctor's attorney will go ahead and get copies of your records, now they will go through and read all of those records. And that's great, because now it will simply confirm everything that we gave to them. So the defense has the mentality that says, okay, we understand you're giving us copies of the patient's records, but how do we know if you didn't take something out? How do we know that you didn't alter something? So they're saying, okay, I recognize that may happen. Let's get copies directly from the source. Let's get it from your treating doctors and the hospitals. And that's what they do. So we get the records at the very beginning of your case before we actually can start a lawsuit. Now, months down the road, what happens? The defense does the same exact thing. They will get copies of your records just many months later. And now, once they get copies of the records, they'll be in the same position that we were in to evaluate it. And what's that? They will have their medical experts review the records just as we did. And now, what's remarkable is that they will come to different conclusions than our expert did. Rarely, if ever, I'm telling you, I've been doing this more than 30 years. Rarely, if ever, will the defense's experts tell the attorney, hey, listen, Oginski and his client are right and their expert is right. You should roll over and pay them whatever they ask for. No. Even if that's true, that's not what happens and that's not what they're going to do. So they will have medical experts who are going to contradict exactly what our experts have to say, And guess what? That means now we're going through the litigation process. And that's the whole purpose of why we give these medical records to the defense, so that they can evaluate what exactly happened. They can have their medical experts look at it and see whether or not they agree or disagree with our experts. So why do I share this beautiful information on this gorgeous day today here in Great Neck? I share it with you because, you know what, nobody really talks about this. And I think it's so important that if you're contemplating bringing a lawsuit for your own matter that happened here in New York, and you have not done so yet, that it's critical to know and understand how these types of cases work. That's exactly why I create these videos, especially bringing you on a beautiful walk today through the town. You know, I recognize that you likely have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day. Bye-bye, everybody.